The Griswold decision is also important because it set the stage for a number of other issues that are debated in the context of the right to privacy. The first of these came in the critical case Roe v. Wade in 1973. Did the constitutional right to privacy include a woman's right to terminate her pregnancy? The case involved a law of the state of Texas that prohibited abortions except in cases in which 3 physicians concurred that carrying the pregnancy to term would pose an unacceptable risk to the life of the woman. Jane Roe, a pseudonym used by the court to protect the identity of the woman involved, sought an injunction from state law to terminate her pregnancy and a holding that the Texas law was invalid. The state of Texas made 2 basic arguments before the Supreme Court. First, the state had an interest in protecting the health and safety of pregnant women. The abortion procedure, the state contended, was dangerous to the woman and that Texas could prohibit the procedure on that basis. The Supreme Court rejected that argument, finding that the abortion procedure was relatively safe for women so long as it is performed under clinical conditions. Therefore, the state does not have an interest in this area that is so compelling as to permit the state to prohibit abortions. The state does have an interest in protecting the health and safety of women and may therefore regulate the conditions under which the procedure is performed. For example, the state may require that abortions be performed in state-licensed clinics by licensed clinicians. Second, Texas argued that it had an interest in protecting the potential life of the fetus and could prohibit abortions on that basis. The court held that the state's interest in this matter did not become compelling until the point of viability, the point at which a prematurely born infant can sustain life on its own outside of the mother's uterus. In 1973, at the time of the court's decision in Roe v. Wade, the earliest any infant had been born and survived was the 27th week of pregnancy, or the end of the 2nd trimester. Writing the majority opinion of the court, Justice Blackmun left no reason to believe that the 27th week of pregnancy would always be considered the point of viability, only that the state of medical knowledge and technology that existed in 1973 indicated the 27th week. Presumably, at some point in the future, medical capabilities might be able to sustain prematurely born infants at earlier points in the pregnancy. This would suggest that the interest of the state would become compelling sooner, and it could, if it chose to do so, prohibit abortions at that earlier point. The bottom line in the Roe decision is that the right to privacy does protect a woman's decision to terminate her pregnancy, but it is a qualified right subject to the state's interest that becomes compelling at the point of viability.